Thank you all for coming this morning. This is a working group, commonly referred to as stakeholders, also known as stakeholders, for Group 1 of the 2018 Auto Industry Division / Board rulemaking agenda. I just wanted to quickly go over the agenda and then we'll kind of jump into it. But before we do that, I suppose if everybody's satisfied with what we sent out, we can just say it's good and go home. So, no? Okay.
Good try.
So I'm going to do welcome and introductions here in a second, and discussion of the process that we're going to take on today. Then there'll be an informational discussion about the move from Title 12 to Title 44, and Mr. Jones is going to take us through that. Then we get into the meat of what we're doing here, the working group meeting scope, and I'll turn that over to Mr. Beebe and Mr. Jones at that point in time. At the end, public comments from whoever is in the public, and then we'll talk about if there's a need for a second rulemaking meeting, and we've already kind of got that scheduled. So that's the agenda as it has been posted, and which all of you should have received in a blast email from Mr. Beebe last week. So what I know everybody that's at the table here, everybody that's at the table, with the exception of Dave, have been through this process with us before. We're following somewhat the same process as far as how we go through this. So remember that this is a recorded meeting, and the reason for the recording is we put the agenda on our website. We put the minutes on our website within a few days. Those minutes are at a very, very high level, but we also put the recording on the website, and the purpose for the recording is for everybody that's not here to listen to what happened, what the discussion was, if they're so inclined, and it's also valuable for the board to hear those discussions if the board members want to take the time to listen to those discussions, because ultimately what we do here will eventually come back before the Motor Vehicle Dealer Board, because obviously you all know that they are they have all the power to promulgate the rule and change the rule and modify the rule, so on and so forth. The power of that really rests with the Motor Vehicle Dealer Board. So what I always do is I start off with everybody introducing themselves, so whoever's listening to the tape at a future date will know who was in attendance today. So with that, I'll introduce myself. We'll go around the table to my right. For the record, I'm Bruce Zuloff, Director of the Auto Industry Division and also Executive Secretary to the Colorado Motor Vehicle Dealer Board.
Leland Beebe, the Legal Assistant to the Auto Industry Division.
Bradford Jones from the Colorado Attorney General's Office on behalf of the Division and the Motor Vehicle Dealer Board.
Steve Perkins, used car dealer, also a member of the Motor Vehicle Dealer Board, although I am not here representing the board.
Jerry Abood, Power Sports Dealers.
Matthew Brooks, Colorado Auto Dealers Association.
Michael Dommermuth on behalf of the Colorado Automobile Dealers Association.
Carolyn Berry, Department of Revenue. Susan Carr, Department of Revenue.
Beth Spellerberg, Deputy Executive Secretary to the Motor Vehicle Dealer Board.
Mike McKinnon on behalf of CIADA.
David Cardella, President of Mountain States Auto Group and past President, Chairman of the Board of CIADA.
Todd O'Connell, CIADA.
Arlene Tapanen, Meeting Recorder.
Chris Hartman, Auto Industry Division, Agent in Charge.
I'm Josh Dexter, Auto Industry Division, Investigative Supervisor.
Frank Agos, Investigative Supervisor, Auto Industry Division.
Just a couple of guidelines this morning on agenda item number 2 is that we want, obviously we want participation from everybody that wants to participate in the way of discussion items. We will have plenty of time set aside. We have scheduled this, the division has scheduled this for an all-day meeting. We will be here until there is nothing further to discuss at this meeting. That may be 3 hours from now, 2 hours from now, or that may be all day. We have committed all day to this, the division has. We've talked about the agenda. We'll try to stick to that process. What I would always do is I always ask everybody everybody in attendance is when you're speaking, make sure you speak up so we get a good, clear recording of what you're saying. And please be respectful to each other. There can be differences of opinions in these types of meetings. Please ensure that you're not talking over the top of somebody. Let somebody finish their thought process and then jump in if you want to agree or disagree, so on and so forth. That's what this meeting is all about. Obviously, the goal of these meetings is to come out of it and have somewhat of a consensus going forward to take it to the board, but that's sometimes not always possible, okay? So just professional courtesy is what I ask for on this. So with that, I think we'll go to the next agenda item, which is actually number 2 and number 3 sort of I just took care of together. The next agenda item is item number 4, which Mr. Jones is going to talk about how this may or may not impact the statutory move from Title 12 to Title 44.
Thank you, Mr. Zula. So as I think everyone is aware, the General Assembly earlier this year passed a bill moving Title 12 to Title 44 with respect to the Auto Industry Division. That move is to occur as effective October 1st of this year. What that means for purposes of the board's rules and this rulemaking process is that the transition of the rules to the new naming convention, because the current naming convention starts with 12, 6, and then either Part 1 or Part 5, depending on whether it's motor vehicle or power sports. That has to be changed, and that has to go into effect as of October 1st of this year. The General Assembly a couple of years ago passed a bill that amended the APA that accounts for this, and we're going to be following that process. What that means is that the division and the Attorney General's office are going to work together. We make non-substantive changes, and what that means is that the changes are just going to be based on the statutory citations in the rules. And we are modifying those from Title 12 to the new Title 44, so those are accurate. And then in accordance with the APA, the Attorney General's office will issue a letter/opinion indicating that the changes are not substantive in nature and they're just procedural. Our hope, in order to get this done by October and give the Secretary of State's office enough time to do this, is get that submitted in the anywhere from like the next 2 to about 4 weeks, hopefully sooner rather than later. How it affects the current rulemaking process as well as Group 2 that's coming up later this fall is that for the first group, we may have to wait because the planned rulemaking hearing for this first group is going to be in September. We may have to pass the rules as they are currently with the reference to Title 12, and then I will have to complete, along with the division, a subsequent letter just kind of converting them to the new naming convention. I think even though it's more of a hassle on our end, I think that's the easiest way to do it and it's the clearest path. With Group 2, however, it's going to be slightly different. What that means is in the stakeholder meetings, depending where we're at, or ultimately the rulemaking hearing that is scheduled in October for Group 2, we may be changing that at that time and the naming reference at that time. So if you have any questions, let me know, but that's just a very general overview of what changes you can expect coming.
Any questions for Mr. Jones around that issue? Okay, we're going to move to item number 5, which is the working group, the scope of the working group. And I'm going to turn this almost exclusively over, at least to guide us through this, to Mr. Beebe. But before I do that. He has some prepared things that he wants to say about, I believe he's some things about the APA and the history and so on and so forth. But I want to tell everybody, we did things on these groups, we did things a little different, and the reason we did a little different is, quite honestly, to move the process along quicker. Now, we've got to be cautious that moving it along quicker that we don't necessarily miss something. But historically, we, meaning the division and the board, have failed at rulemaking in the terms of the statutory requirements of 20%. 20% of your rules are reviewed every year. We have failed. So we had a huge discussion with staff and the Attorney General's office weeks ago about changing the process a little bit to see if we can facilitate moving the process along a little bit more efficiently and quickly without losing substance that is so important. This particular group of rules, there are some that we would call low-hanging fruit that probably don't need changed or is very little, and then there's some that Mr. Beebe will get into that we have made some formatting changes that he will explain in detail. Okay, so that was the purpose of the way we did it. Will we do it that way every time? Probably not. There are certain rules that we certainly want industry input on before we have this meeting. But this particular group is more of an interaction, sort of, there are rules, but there's sort of policy issues between how the division interacts with the board and what the board ends up doing. So it made sense for us as the division and the AG's office to spend some quality time pre-drafting what we think it should be for discussion, and we have a big discussion on, you know, where you see the problems with the pre-draft type situation. So that's the reason that we did it that way. We spent probably staff, myself and Ms. Rouse, Mr. Beebe, and Mr. Jones, we spent in the last 3 weeks or 4 weeks a ton of time trying to figure out how best we could reformat some of these rules and bring them into 2018. So that's kind of all I say. I don't know. I don't want to steal any thunder from Mr. Beebe if he was going to say those things or not, but I'll turn it over to him to kind of guide the rest of the discussion.
Thank you very much, Bruce, and no, you didn't steal any thunder. I don't have any. What I do have are some important introductory comments. When one approaches drafting of any rules, whether it's revisions or new rules, there are certain types of things that you must consider. And I am going to make the record of the kinds of things, the kinds of questions that are asked by staff and would be asked by any of you drafting if you're proposing from the outside. Okay, first of all, have any relevant changes to authorizing statutes occurred to which the board must respond? Okay, there are occasions, as you well know, when something can so radically change that a rule that was perfect before is totally irrelevant now. Okay, so we always have to ask that question. Okay, then, when we look at existing rules to make revisions, one of the things that we have to consider is the outside scope of the authorizing statutes. And when I say the outside, it's the perimeter. How far does a statute allow an agency to reach in a rulemaking? It cannot go beyond the scope of a statute. So the question, is something outside the scope of an existing statute that is therefore not permitted under an authorizing statute? That's always a question. Another question, is something unconstitutional under Colorado and U.S. constitutions? This is not a static question. Things change. Courts reinterpret. Even constitutions change. So we have to reflect those changes or consider the possibilities. Are any of the provisions overlapping or duplicative of other rules. Again, this can happen inadvertently in an agency that has a lot of rules developed across a long period of time and does not review every rule every year. So we look. Are any of these provisions unnecessary because the authorizing statutes provide sufficient guidance? Well, they may have changed and they now do provide sufficient guidance, or they may have originally provided sufficient guidance and experience has taught us that the rule is still not necessary. Are any of the provisions inadequate to achieve the aims of the authorizing statutes? For example, inadequate to address relevant policy matters like consumer protection, healthy business competition, etc. These are matters that every agency, because every agency deals in policy, has to consider. And of course, the kinds of technical things that change in time. Are any of these provisions written unclearly according to modern legal drafting standards, including, for example, the plain English requirement, and of course, strict adherence to English language conventions of grammar, syntax, spelling, punctuation, etc. I will tell you as an attorney, the number of things that you find just looking at a statute and looking at the rules related to it that have changed in the course of time because the conventions of writing have changed. We must ultimately pass rules that will go through the review not only of the Attorney General's office, but a much stricter scrutiny by the Office of Legislative Legal Counsel, okay? And they look very critically at whether something makes sense in terms of all these technicalities, because they know that if it does not make sense, it is an occasion for later dispute. So they want modern language conventions to be applied. So something may have been written very well 10 years, 15, 20 years ago by the conventions then. But we must look to the conventions now whenever we revise or establish a new rule. So those are the kinds of drafting process considerations that went into our thinking in drafting what you have before you and which we're going to discuss. Now, a second matter that we are obliged to deal with is that we must deal with both Part 1 and Part 5. That is, with the motor vehicle related and the power sports vehicle related materials. For the most part, these are literally parallel legal considerations. Not always. There are some things unique to one side or unique to another, but there are also unintended discrepancies or unintended or unspoken of matters. We run into nearly every time we review a motor vehicle related rule that there is no matching power sports related rule. And if you're tempted to say, really? So how in the world did you ever enforce in the power sports context? I think we'd have to say, by blind luck, we just never had a case. And what we are dealing with is the necessity that when we bring one of these rules up that needs a parallel, that we develop a parallel. So that's why you see these things set out today in pairs. And they must be dealt with in pairs. Now, in order to do that, okay, we've already looked at the drafting process, and we've already looked for anything that would look technically discrepant. And, you know, we haven't seen anything substantive enough so that we would create different rules that are near but not complete parallels. However, in this discussion today, there are people who are in the power sports industry particularly, who may be able to say to us that there is a reason to have a difference in language, in which case we'd want them to say that. There will be reference differences, of course, but we're going to take these up as if we're reading just the motor V, which is the A pair in the A and B pairs of each of these sets. And then we're going to ask the question each time, is there a reason to look differently at this from the power sports side? Now, just as a management matter, when we sent out the email, which included the agenda, which included a list of the rules, the implicit understanding that we gave you is that they'd be taken up in that order. As staff, we have determined a better order is needed because of a particularly important thing that we've done with one rule. So the order of rules will be changed just for this discussion. So what I will direct you to is that rule pair 6 is going to be moved to follow rule pair 2. That is the only change. Otherwise, everything will be the same. Again, rule pair 6 will follow rule pair 2. Obviously, it precedes rule pair 3. Are there any questions about any of these process considerations? Okay. So we're going to launch immediately into rule pair 1. Again, we based our drafting and our concepts of how to deal with this primarily on every consideration that you've heard. Unfortunately, one of the things that we looked at was the idea that we would make no changes to this rule. And after further consideration, and basically I'm going to say it's based upon the significant legislation promoted by CIADA that was passed in the 2017 legislative session as House Bill 17-1249 that has then been amended in the 2018 legislative session by House Bill 18-1105. The staff no longer sees a reason to retain this rule. And therefore, we're now recommending this rule be deleted. There is no parallel rule in the power sports side, and at this point the staff would not be urging that there be one created. So this is the moment, if you have questions or comments or concerns about this now proposed deletion of this rule. And thank you, CIADA, for advancing the ball quite a ways.
Any concerns with maybe just deleting the rule? Quite frankly, it's a statute that is never, ever used. Don't contemplate ever using the statute. There's always a first time, but the statute's never been used since I've been here. And we tried to do a little research, and we don't think the statute has been used for 20 years. The rule was attached to the statute in 2007, coming out of the last sunset review, for some kind of obvious reasons about what happened in 2007 with the sunset review and where the board was at, where the division was at, and where the attorney general was at. But it just seems like it is it's just something not necessary. I will tell you, obviously, that, and I think you all know this from the people that spend any time at the legislature listening to the legislature. The legislature is kind of constantly driving agencies towards when you get into these stakeholder meetings, rulemaking, is get rid of anything that really isn't necessary. Reduce the rules rather than add to the rules. And this would be one of those that, as the staff looked at this rule and really analyzed it, we just thought, wow, is there really a need for a rule here at all? So, discussion.
I think what we did at the legislature has teeth, and it really allows now for the criminal component, which needs to happen, versus burdening the division and the board when you're going to get a much better result on a criminal level, to be honest with you.
And I believe there's been some success, at least some initial immediate success with the changes, so.
Yeah, which we wouldn't have had before, but for the changes.
CIADA have any? CADA.
You can drop one.
They're all draft ones.
Right.
Remember.
We don't have any, no comment on that.
And just a point of reference, the change that occurred was through House Bill 17-1249 from the 2017 legislation, and that added a provision under 126121.
Can you illuminate on what that specific change was? And then it was revised again in 18?
It was corrected in 18.
Corrected in?
The change, well, I can say, it was their bill, so they probably should speak to it, but in a real general way, it added teeth to the fining authority for a criminal summons. It required, it mandated the county court judge to fine at a certain level, and it mandated that where that fine went, came back, half of it has to come back into the dealer licensing fund. So the bill was crafted. I don't think there was very little, if any, negative comments. I believe that CADA supported that. It was CIADA's bill, and so it passed in the 2017 legislative session. There was a technical error to the drafting of the legislation, which we caught in 2017, and we wrote a technical on it. That's what was revised. And what happened in 2017, it said that the fine goes into the dealer licensing fund, but in that statute, 126123, I bet, it said that no fine can come into that. So there was just, it was missed by probably the drafter on that point in time. So in 2000, we wrote a technical, and then we encouraged CIADA to try to find a sponsor to correct that, which they did this last legislative session. So that now has been corrected. So the fine now has a place to land. I mean, it would say whatever you want to say above and beyond that. So
It's just really what it is at this point, because DAs before, unlicensed stuff's not sexy, but now it said to them, hey, this is obviously pretty serious, so we're gonna, because of minimum mandatory fines, it's taken much more seriously. I've represented unlicensed throughout the years, and you get a DA who gives you a 3-month deferred judgment, that kind of defeats sometimes the purpose of what it is, which is to either get compliance or get them out completely, because it's hurting the rest of the business.
I think basically what we did was to try to clean up and make it more efficient and protect our industry and protect the consumer along the way. And that's, which basically wasn't happening under the old rule.
Does that answer your question, Mr. Perkins? Okay.
further comment? Hearing no dissension to that, then we will proceed. Not that you can't come back at a later date and say, wait a minute, obviously you have that option, but we will proceed with the thought that we are going to recommend to the board, at least at this point in time at the hearing, that this rule just be deleted. Is that the right language? Mm-hmm. Okay. So, Mr. Beebe.
Well, rule pair 2 is a bit more complicated. Okay. And it requires some history. And there is a significant history, and the highlights of this history are as follows. In the years between 2004 and 2006, many concerns surfaced and complaints were made about the board's alleged inconsistency and unfairness in its determinations of sanctions against licensees. A then existing statutory provision, Section 12-6-104, parent 3, parent N, had been ignored by the board for many years. That provision stated, here it is, the board is authorized and empowered to promulgate guidelines in the form of rules and regulations to ensure that administrative penalties are equitably assessed and commensurate with the seriousness of the violation. The statutory language did not mandate that the board take the action to create such rules. It merely authorized and empowered the board to do so. The board did not create the regulations that would ensure its sanctions were equitable and commensurate with the seriousness of the violation. Therefore, in the 2006 Sunset Review process, the Sunset Reviewer in DORA, who does a 360-degree look at everybody and everything, received many complaints about the board's history of sanctioning licensees. As a result, recommendation number 10 of the 2006 Sunset Review stated, quote, the Auto Industry Division and the board should develop and utilize a viable and consistent set of compliance and disciplinary standards by January 1st, 2008. The sunset legislation that followed began by deleting the former merely empowering and aspirational provisions of Section 12.6.104.3N. It replaced those provisions with a severely time-constrained mandate that we see in Section 12.6.104, parent 4. Section 12.6.104, parent 4 states, the board shall promulgate rules by January 1st, 2008, establishing enforcement and compliance standards to ensure that administrative penalties are equitably assessed and commensurate with the seriousness of the violation. After that legislation had been signed into law, the board then quickly promulgated the current formulation of 1 CCR 205-1 regulation number 12.6.104.4 in response to the legislative mandate. That's the regulation you see in front of you. This regulation, as developed in 2007, has remained without review and without change for the last 11 years. Now, when staff examined this rule using these drafting process considerations that I spoke of earlier, a number of issues were visible. Among them were concerns about some of the provisions in the rule exceeding the scope of the authorizing statute as that statute now exists. That is to say, provisions without permission, therefore provisions that might be considered unlawful. In order to speak to that matter, I'd like to turn the discussion on that over to Attorney General Participant Brad Jones, who can address more specifically.
So the issues that have been coming up recently with the Office of Legislative Legal Services, OLLS as they're commonly referred to, is that any rules that are promulgated by the agency, they review closely. And in the last few years, they've been really focusing on whether there is statutory authority that permits a rule. If there is not, every single year they refer a number of rules throughout the state with all the different state agencies to the Committee on Legislative Services. And they will review the rules, and if they make a determination, they will decide that the rule is unnecessary or without authority, so beyond the scope of the statute, and they will eliminate it. There's a bill that's introduced every single legislative session each year that lists the bills that should be eliminated. And then it's up to state agencies to determine whether the rule is necessary. If so, to seek a legislative fix, or the bill will end up dying, and then this the rule will end up dying upon the passage of the bill. And then the state agency will have to figure out whether to pass an emergency bill that complies with the statutory authority. Because of that, reading 104 paren 4, the language, and then referencing the regulation, it appeared that much of this regulation was beyond the scope of that particular authority. Now, the naming convention that the Motor Vehicle Dealer Board is currently using is a little bit different from the standard naming convention that a bunch of other agencies are using right now. What I mean by that is it clearly lists the statutory provision that it's referring to, and that is going to garner the attention of OLLS when they review it, because that is going to be the emphasized statutory provision that they're going to be looking at. So with that understanding, when we addressed the regulation 104 paren 4, we were looking specifically at what areas it covered. And it addresses penalties in a portion of it, but it also addresses how the division and the Motor Vehicle Dealer Board address affidavits. We determined that is a better, there's a better place for it. And that is why pair 6 is being moved up to follow pair 2, because those are the rules that are being created based on that discussion and that determination. And in particular, the statutory provision that I believe is a better reference, that we determine is a better reference for it, is 12.6.104 3F Roman numeral, or paren Roman numeral 2. And we can address that in pair 6. But many of these provisions that are currently listed out in the current regulation of 104 paren 4. Additionally, there were concerns with the language, whether it's still necessary. There's a few provisions that are no longer necessary because of the sunset changes that occurred last year, especially with the authority that was granted to the division and the director of the division under 12.6.105. So those provisions were no longer necessary, and the division decided it would be better to modify the current 104.4 and just focus its scope solely on addressing penalties against licensees in disciplinary cases, and then create a separate rule and provision which is laid out in pair 6. Does anybody have any questions at this time based on that information? Okay, I turn it back to you.
Okay, all right. You did steal some of my thunder.
I thought I would.
Yeah. No, specifically, I was going to bring up the fact that the reason for pair 6 is that we did see this cleavage opportunity that would clean up, this whole matter and still really provide, the guidance material that the public and the regulated community needs to see about the process with affidavits. Okay, now, at this point, although it may seem obnoxious, I am going to read into the record the language of the proposed change to 12.6.104.4. And you have it in front of you, so you can go to sleep for 2 or 3 minutes. Okay, the board shall use the following criteria to determine the appropriate sanctions for a licensee in a disciplinary case. Parent A, whenever a provision of Part 1 of Article 6 of Title 12 mandates a specific sanction for either Parent 1, a specific type of violation, or Parent 2, a specific circumstance related to a specific violation, the board shall apply the mandatory sanction when the findings of fact and conclusions of law establish the legal basis. Parent B, whenever the legal basis for a mandatory sanction does not exist, the board shall exercise its discretion to determine the appropriate sanctions based not only upon the findings of fact and conclusions of law in the case, but also upon a standardized approach that takes the following factors into account. Parent 1, the nature of the violation. Parent 2, the severity of the violation. Parent 3, the characteristics of the harm that the violation produced. Parent 4, the monetary harm the violation produced. Parent 5, the licensee's history of violations. Parent 6, the licensee's compliance with prior board orders. Parent 7, additional aggravating information. And Parent 8, mitigating information, including but not limited to the licensee's voluntary monetary remuneration to a victim. And Parent C, whenever the board considers a fine to be an appropriate sanction, it shall follow these restrictions. Parent 1, the fine must be punitive, not compensatory. And Parent 2, the fine must not exceed any relevant limitations on the amount of the fine as set out in Part 1 of Article 6 of Title 12. Now, I am going to take a step here to annotate something in anticipation of someone recognizing that there's a question sitting there. If you look back at Parent A, okay, it sets out two places where there might be a mandatory sanction. One, a specific type of violation, and two, a specific circumstance related to a specific violation. We have statutes that set out specific types of violations as requiring mandatory disqualification. Example is an odometer type of case that we can see in the record of the person. And then we have the kind where we're looking at a criminal violation that falls under Titles 3, 4, or 5 of 18. And that's a specific circumstance related to a specific violation. We haven't used that first one very often, but it needs to be included in this analysis because it could happen. Okay, so that's important. And the other thing is that we had feedback concerning Parent B, Parent 8, the mitigating information including but not limited to the licensee's voluntary monetary remuneration to a victim. The outside community of interested individuals, the dealership community, had, suggested there be a way that kind of thing be considered. And this is a response to that suggestion. So some of this stuff, we did have a little more than just our reviewing standards that we were considering. Okay? And the final thing is just to use this as an illustration. Obviously in the power sports version of this, like in Part A, it wouldn't be whenever a provision of Part 1 of Article 6 of Title 12 mandates. It would be whenever a provision of Part 5. So that's an example of where there is a referential change that is necessitated by the existence of Part 5 separate from Part 1. Okay, now I think I might still have a comment more. I'm going to get back to the beginning. No. Okay. So are there any questions or concerns about this rule as it is drafted now? And that would include any suggested changes to draft language if you have them.
Michael Domermuth on behalf of CADA. And under subpart B, I appreciate the inclusion of the factors there, but I would want to include language that doesn't tie the board's hand to only consider those factors. There may be additional mitigating or aggravating factors that the board should have the right to consider that aren't enumerated under subpart B. So some type of language that would allow the board to consider a wider range of factors. I don't necessarily think we need to list them. I can think of a couple that might come into play, but just to allow the board some flexibility to consider factors that aren't enumerated here might be a good idea.
Okay. Now, so at this point, Mr. Domermuth, looking at parent B and subparent 7 and 8, okay, the factors 1 through 6 before 7 are essentially aggravators, and parent 7 says additional aggravating information. Does that not open aggravation up wide enough for other considerations?
Well, it does, but for instance, 5 is not necessarily an aggravating factor.
Oh, no,
And
that's true.
That could be a mitigating factor. This could be the licensee's first appearance before the board on a violation.
Okay.
So, you know, there's some confusion there. And it does, the word additional is not included in front of mitigating as well.
Right.
So, you know, that would be a potential way to solve my concern. And just to broaden it further, to say any additional aggravating information or any additional mitigating information that the licensee might care to present would give the board greater latitude and again, address a wide variety of situations that might be before the board in assessing a penalty.
Yeah, that's easy to do. Does anyone disagree with that suggestion? Well, I'd be happy to redraft to consider that exactly. Are there any other?
Anything more on that?
Yeah.
No, you know, Bruce, I've just been thinking about, you know, over the years in settlement meetings where we discuss the factors that go into considering a settlement. For instance, if it's a self-reported violation, that would be a mitigating factor. Another mitigating factor that I frequently bring up is whether the dealership has taken steps to prevent problems of a similar nature in the future. Have they put in policies, guidelines, and procedures to prevent that sort of thing from ever happening again? Perhaps a dealership had a problem employee who's no longer at that dealership who is creating the problem. That would be a mitigating factor if the dealership has terminated that employee. So why I could, you know, we could probably sit here for hours and come up with factors that should be considered by the board. I think to give the board greater latitude would be a good thing. I mean, these are, in a sense, sentencing guidelines, and I always hate to tie people's hands with sentencing guidelines. So,
Mr. Domermuth, do you think that something what I thought I heard you say, any additional aggravating circumstances or any additional mitigating circumstances, do you think that gets there?
Yeah.
Okay. Yeah. Because everything you said, everything you listed is very accurate as far as mitigation. Yeah.
And a couple of just, and I guess, how does this work from the standpoint of, let's say you have an ALJ, they go ahead and issue an initial decision, the board goes ahead and reviews, then looks at sanctions. They're going to have to make actual written findings as to these factors. Is that something that needs to, I mean, the AG will, go ahead and tell them, by the way, you need to go ahead and address these specific factors in your final written decision. Or does that need to be put in there that, because from my perspective, I want to know that the board addressed each one of them based upon the information was provided, saying, that this is, they didn't deliver title in 30 days. Nobody was hurt. First violation. I want all that stuff so I know if there's going to be an appeal, the Court of Appeals has specific information as to how they got to that sanction. Is that?
I can respond in the sense, well, first of all, I'm not going to be advising the board at that point. It would be conflicts counsel. I guess my approach, and I think you and I would see eye to eye on this, is if we were appearing before an ALJ or a hearing officer, we would say, here are the factors that need to be considered with regard to penalties. And I know from our previous cases together, these are issues that we bring up together, why a certain penalty is appropriate or there's mitigating information and all of that. So I think this just outlines it more clearly for a consideration. And we would say that this is a board rule, this is what the board's gonna have to consider, therefore the ALJ or hearing officer would need to address it. So from my standpoint, I would try to address this at the ALJ hearing officer level so the record is clear when it goes up to the board, if and when it goes up to the board. And then I'm guessing that's what conflicts counsel would do. I don't know what the findings of facts or the conclusions of law are, what they would have to do regarding the penalties, because I think that is particular to whatever case is before them and the circumstances that are involved, but that would have to be conflicts counsel advising about that point.
Well, and I get that, but because it says the board shall, so basically we're past ALJ part. ALJ gets to do what ALJ argued, but we're to that point now where I need to make a record, and I need to say, all right, board, I would like written findings as to this. Is that how you anticipate? And again, let's take the Astro case. I mean, the Astro case is, all the factors are there. If had this been in place, I would have said, okay, here's what I want you to do writing wise, or in a written order to get that. Is that how you anticipate that's going to be as part of, whether it be?
Mike, I'd have to say that reasonably, and I love that word, okay? Reasonably, the board would consider all these factors. Would they consider them as a laundry list and say to themselves each moment that they're making a decision, have we looked at the nature of the violation? Have we looked at the severity? Well, the advocates before them, I think, are the ones that have to push that to ensure that.
Right.
And you're a good advocate.
Oh, don't you do that then.
Well, why not? Why not? I think we've got two good advocates sitting here, and Mike being another one. I think you guys stand for your client very well, and that's why you made this point. I don't think you can just say, board, just do your job. I think that this gives you the arrows in the quiver to ensure that if there's a feature that fits under one of these, that it's exposed. And I would not imagine the Attorney General would have any objection to your exposing anything that is real, because he or she's going to do the same thing.
Well, I'm going to overlook the fact you didn't include me in the advocate. But Mike, I anticipate if you and I ended up before the board on something, we could make a request, based on these factors,
right.
Why we think it's right, why you think one circumstance is right, and if it should be in the board order.
And that's fine. And then the second part of that was, as far as on the licensee history violations, is with the current STIPs, because some of the way the STIPs are written is, it's not actually an admission to a violation. How's the board going to address the fact that there was a STIP, but there's not an admission to a violation? As that factor.
Do you mean in the consideration of a STIP or
yeah,
in future
okay,
case?
so I'm trying to think which on a level one, if we're doing a level 1.
And some level 2s.
On some level 2s, I mean, there's not an actual admission to a violation. It's that, what's the language?
There's sufficient credible evidence.
Credible evidence.
Yeah.
So how is the board going to distinguish between the fact that there was a stip, but not an admission to a violation?
I think the way that I look at that is I am, when I sit down with you, Mr. Don Remuth, and I am negotiating something, I am acting on behalf of the board. So I'm considering those things, those factors, when I say this is a level 1, or I'm going to offer a level 1 with no admission, or level 2 with no admission. So I'm already considering some of those things when I bring that to the board. Most of the time, I spend enough time with the board to talk about that why I made this offer and why the dealer and the attorney for the dealer accepted that, and we talk in kind of general terms about those issues. Obviously, the board can say we want to do something else, and doesn't happen very often, but it has happened. So I don't know if that answers your question or not.
It does. I just still, and I don't want the board to be in a position where all of a sudden they're saying, okay, you know, we had a failure to deliver title within 30 days, a level 1, whatever it is, and it's technically there's a stipulation. And I look at it this way: you're on probation, and after that probationary period's up, I would want to look at it and say, you know, can we use that against you in a non-delivery situation? Under this rule, it would be yes, but we don't have an actual admission to a violation. We have an allegation of a violation. Do you understand the distinction?
Absolutely, and I think...
And I trust with the way you're going to do it. I just don't want the board to, you know, every now and again they get carried away and say, oh no, you know, we've got this, and this, and in fact, I'd say, hey, those are not violations. They were allegations of violations. So, you know, you can't use that as an aggravator.
I certainly think that, I think the board could look at it differently, but I certainly think that you as a representing attorney could make that hard argument, and it would have to come down, because I totally see your point on that.
Okay. Actually, I hate to see I think the way you know, how the stip's evolved, I think this is probably the best course we've seen throughout all the years I've been here, how the STIPs are done and the way it's done now. I think that's just great. I just don't want to set the board up or set a client up where it's like, oh, you know, now we have something that you told me was not an admission on our part.
So I want to go back to your first question, make sure I understood your first question. We talked about hearing, okay, and the factors that an ALJ may consider. Obviously, this rule does not box an ALJ into anything,
right?
Okay, but a hearing before the board, then the attorneys would argue all of those factors and certainly ask for, in a final order, for consideration before a fine, all of these factors.
Right.
I mean, is that a correct statement? At an ALJ level, the same thing would happen, but the board may not see that depending on how that order is drafted. Findings of facts, which we know that the board can't really get in there and do much. Conclusions of law, the board can take a different approach under the advice of conflicts counsel if they so choose to do that. But under the conclusions of law, if either an ALJ or a hearing officer, if there was good arguments by both sides, and a hearing officer and ALJ should obviously put conclusions of law that factor in a lot of these issues, and then of course the recommended orders. So, you know, and then there's a point if they do not. There's this, you know, there's exceptions that can be filed to ask the board specifically to look at those particular conclusions that one side or the other doesn't think was properly drafted or considered in the actual hearing. So, I mean, I'm kind of rambling, Mike. But that's sort of the way I look at it. Is that certainly in a hearing before the board, a little bit different situation than a hearing before the ALJ or a hearing hearing officer. But the bottom line is, every one of those, if there is any red flag that I see or any concern from either side, especially in consideration, those come back to the board for the board's final approval. The only ones that don't come back before the board, if it's a denial and there is the findings of facts and conclusions of law in the recommended order are solid, and there is no request by either side for any further information, then by delegation of authority, those can just be passed through after the 30-day window of notification is taking place.
Yeah, because I think, because historically the ALJs without this, I mean, they throw something out there. They throw a number out there. They throw a sanction out there without this. But from your standpoint, our standpoint, it would be, yes, here you have to get this. And if they don't get it into the writing, at least the board has the ability to go ahead and correct the conclusions of law at that point to address this part of it. So that's all, there's a layer. So it happens at ALJ, but we want it to happen more specifically at the board level at the end of the day.
Yeah, I think you and I are in agreement
Right, okay.
With that. I just can't speak for conflicts counsel and what
Right.
they're going to advise the board at that point, so.
So based on that, Mike, do you think there's any need to, putting in Mr. Domermuth's a couple of bullet points or concerns, any further thing that needs?
I think it did a great job. Fine, I mean, it's good. It's something that has been needed to consider, be in writing to have the board consider instead of all over the place. And the nice thing is, these are factors that you use looking at the STIP part of it, so it's consistency throughout. And that's what I think is needed to happen.
Yeah. I simply wanted to say one little thing. We talked about, very loosely, what we all understand to be processes. Example, we have a process in place, so a disciplinary action begins, and as part of the established process, a stipulation effort can be made short of that moment of, if you will, charges being filed and an actual hearing taking place. The whole point of stipulations is to get around that very costly next move that can be very delayed and have very unpredictable consequences that can result in further procedural matters through exceptions to initial decisions and through further board action. Well, one thing I didn't hear here is important to make sure someone says, I'll say it. Stipulations can fail. They can fail at the launch, they can fail, and their charges are made. Stipulation efforts can fail in the process of stipulating, and the parties can't agree, and notices are filed. We're going to court. Okay. They can also fail at the board determination level. So at the moment the board is going to review a stipulation, okay, it sees what is in front of it, the stipulated result. It sees the affidavit. It may see some mitigating and aggravating factors and things like that through discussion or presentation. But it doesn't have everything, because it's not a hearing. It's a review of a stipulation. And if the board at that moment rejects that stipulation based upon whatever its factors, the choices are pretty limited. The parties can return to the negotiating table, or it can proceed to hearing, or it can be dismissed, unlikely. So, just so everyone's clear that there's certain junctions where people have voices and certain junctions they don't. The review of stipulation can offer outside counsel an opportunity to speak in defense of the stipulation. That has happened. It isn't typical. And so the board can undertake its own initiative to review that stipulation and has the authority to reject it. And there's, but two ways after that. I just want to make sure everyone does know that. This is not an instrument designed to solve failing stipulations. This is just designed to set up standards to help in the stipulation process or to help the board to guide its judgment at whatever ultimate moment it makes that judgment. So that's it. And you hope that you're going to get the ALJ or the hearing officer to pay attention to this, because they're supposed to follow the board's rules, substantive rules. They are. They just don't always. And that's when you take exceptions, if that is the course you want to take. So that's the process moment. Any further concerns? Are there any further comments on this rule draft? Are we prepared to take a break?
Yeah, I was just going to say that before we move to the next rule. We've been here a little over an hour, so it's probably a good time to take a 5 or 10 minute break so people can refresh. So, take a break at 10:15.
Okay.
Okay, we're back on the record. It's 10:29, and I think where we left off was we finished Rule Pair 2, and we're making a couple of minor modifications per Mr. Domermuth's request to do that one area, and I think we're ready to look at Rule Pair 6.
Yep.
Okay, Mr. Beebe.
Thank you. Okay, by way of introduction here, this is a brand new rule for both motor vehicle related and power sports related versions. And as you know, was pointed out in the introduction to the prior rule pair, this is the result of staff review with the recommendation that that prior rule be essentially separated into two pieces. And this is the second of the two pieces. Okay. The staff believes that it is important to memorialize by rule the process that most of us in this room recognize is the regular process that the board uses in disciplinary cases brought to it by the division. The proposed new motor vehicle and power sports regulations read as follows. So bear with me here. Whenever the division refers evidence of a licensee's alleged violations to the board in the form of an affidavit of probable cause, the board shall respond to the affidavit in the following manner. Parent A, if the board does not find probable cause based upon its examination of the affidavit, the board shall do one of the following. Parent 1, suspend its consideration of the matter with a request to the division to bring the matter back to the board with additional information. Or, Parent 2, inform the division that the board declines to prosecute the case. And Parent B, if the board does find probable cause based upon its examination of the affidavit, it may, Parent 1, decline to prosecute the case. Or, Parent 2, prosecute the case in the appropriate venue as follows. Parent I, if the license class of the respondent is a salesperson, the board shall assign the executive director or his or her appointee to hear the case. Or, Parent II, if the license class of the respondent is other than a salesperson, the board shall assign the case for hearing either to the board itself or to the Office of Administrative Courts. Parent C, whenever the board has decided to prosecute the case, it shall do the following. Parent 1, turn the case over to the Attorney General to begin prosecuting the case. Or, Parent 2, authorize the Executive Secretary to, Parent I, attempt to negotiate a settlement of the case without a hearing. And, Parent 2, turn the case over to the Attorney General to begin prosecuting the case. Then, Parent D, Whether the board does or does not find probable cause, based upon its examination of the affidavit, it may, if appropriate, refer the matter to another agency. Now, just as a preliminary note here, let me go back up to where I need to make the comment.
No, they would refer to a DA.
Now, I've lost what I wanted to say here, so I may have to wait. Okay. Yes, I didn't really need to make another comment. Are there any questions or concerns about this rule as it's drafted, including any suggested changes to the draft language?
I have one.
Okay.
I just caught this at the bottom, the very bottom of page 10.
Okay, I have a different,
Okay.
I'll give you a copy.
So, no, it's C2, okay?
C2.
C2. So authorize the executive secretary to attempt to negotiate a settlement of the case without a hearing. So the board, under the current rule, the board has that authority, and it's still there, okay?
right.
It's the word "and." It should be an "or"?
Right.
Because it appears like I have
Oh.
to do both.
Yes.
And so what happens is when the board authorizes me to attempt to negotiate, if I'm unsuccessful, I don't
Right.
need to bring it back to the board. I
Right.
just need to then turn the case over to the Attorney General's office. So I think the "and" should be an "or."
And I think we may have here inadvertently a version that excluded not only the "or," but excluded a tagline, turn the case over to the Attorney General to begin prosecuting the case in the event that the stipulation process is unsuccessful. That's what belongs there.
Yeah, just kind of a common
Yeah,
sense change
absolutely.
there. So anyway.
Okay.
Comments, questions, revisions? I think when staff looked at this, all of this is, we're sort of already doing it already, but it didn't appear where it was resting, it belonged, and it appears that it now rests in a better, underneath a statute that and it's just a little more defining. I don't think anything at all changes, the substance doesn't change at all, or the effort to move that case in that direction.
What percentage is it that the board's supposed to take until?
60/40 at an ALJ level. They're supposed to this board is not supposed to bring back more than 40% to themselves.
Right.
And when they decide to do that, it has to be a unanimous vote of the board. If there's one dissenting, it cannot come back before the board.
Yeah, what Mr. McKinnon's referring to in his question is that there is a separate statutory provision that explicitly limits the number of cases per year that the board can take as disciplinary cases from the beginning before itself. And so at the critical junction where the board's assigning the venue, they have that choice of ALJ or themselves. And they can go up to 40% of the total number of cases per year without exceeding and going into a reporting requirement that is a complication we've never seen we had to do. The statute's more elaborate than you might realize. But the point is the board almost never reaches that level. And some of this is a practical consideration. A hearing before the board is a major process. And to assign itself a hearing is to assign itself 3 or 4 hours probably minimum, and potentially a number of days of hearing. So it's no small matter. Okay?
Well, the question is, just I always bring light to this 60-40 split, understand the reason for the 60-40 split and the reason that the legislature did that. But there's a 60-40 split where it's assigned or when it's actually heard. So, I mean, because of the 100% that come to the board, 99% is given to me to try to attempt to do a stipulation of that 99%. Probably of that percentage, probably 85%, I reach a stipulation, bring it back to the board. So when I do that, does that count towards a 60-40 split? And we've never really tackled that.
Right.
Clearly, if it goes to hearing at either side, that's definitely the 60-40 split. So that's just a little side thing that I've always looked at. When does the 60-40 split really kick in?
When was the 60-40 split put in?
Sunset.
2007.
2007 sunset.
Okay.
Because there was there were many cases going, it's all part of the same history. Cases going before the board, being heard, and the penalties being very disparate, and people feeling inequity was resulting. This was one of the solutions through the sunset recommendations, was to reduce the board's authority to take cases. Prior to that, they had complete authority to assign every case to themselves without exception. So it was stemming what they saw, what the legislature, through the review process of the sunset report, saw as abuses by the board. That's simply put. What's the history?
In the eyes of the sunset.
Well, that legislature is the authority that
Right.
governs everything. Yeah.
So my question would be, if we make that little change, that and/or thing, and add those few words, is there any other thing that anybody has any concerns with this draft and where it lands? Okay?
And that will be mirrored as part of, sorry.
Mr. Boot has a question.
Yeah.
I just wanted to make sure that we noted that the parallel power splits provision.
Precisely. It'll have the same changes. Okay. We're ready to move on to rule pair 3. Feels like we're going backwards, but honestly, I see the end in sight. Lunch coming. Okay. So introductory comments for rule pair 3. The statutory language that authorizes this rule, that is to say section 126104, parent 3, parent A, states, quote, "The board is authorized and empowered to promulgate, amend, and repeal rules reasonably necessary to implement this part 1, including the administration, enforcement, issuance, and denial of licenses to motor vehicle dealers, motor vehicle salespersons, used motor vehicle dealers, wholesale motor vehicle auction dealers, and wholesalers, and the laws of the state of Colorado." The statutory language that I just read explicitly addresses the board's authority to do rulemaking. Let me read the beginning words again. The board is authorized and empowered to promulgate, amend, and repeal rules. That is the guiding concept of this statutory provision. However, the existing regulation does not delegate the board's authority to do rulemaking, but mistakenly delegates enforcement authority of rules and regulations. In other words, it's a miscue on the existing rule. Therefore, as currently worded, this regulation exceeds the scope of the authorizing statute. One remedy for this violation of the scope of the statute would be to delete the rule completely and leave the delegation respective to the actual authority in the statute alone. In other words, let the statute stand as it is, no rule at all. The staff, however, believes the better course is to revise the rule to delegate administrative aspects of rulemaking to the executive secretary and his agents, his or her agents. A need exists for such delegation. Ladies and gentlemen, we are here today in an undelegated authority from the board.
That was my thought.
Yeah.
We need this before we can do anything else.
Yeah, we're done. We just are dead.
This is the chicken and or the egg issue.
Right, right. Well, this is obviously a long-standing foible, if you will. So, the rulemaking activities are currently administered by aid staff according to the provisions of the Administrative Procedure Act, to the governor's executive orders, and the Department of Revenue policies, but without explicit delegation by the board to perform these administrative duties. There is authority for the board to do what it's doing, and they have tacitly let this be administered by the division, by the executive secretary. The staff believes the revised rule will provide the necessary authority, and the revised rule states, the board delegates to the board's executive secretary and his or her agents the authority to assist the board in rulemaking under the State Administrative Procedure Act, Part 1 of Article 4 of Title 24, by performing all administrative acts. That's it. Are there any questions or concerns about this rule as it is drafted to be revised, or any suggestions to changes in that draft language?
The chicken or the egg?
Yeah.
That's
Yeah, exactly. Well, we're going to hash the right one now.
Okay, hearing none, we'll probably just move forward with that type of recommendation when we get to the board.
And the parallel for comment. Okay. Okay, so that's Rule Pair 3. Just a moment. Okay, Rule Pair 4. Introductory comments. The authorizing statute, which is Section 12.6.104, Parent 3, Parent D, Parent 2, for this rule states, quote, the board is authorized and empowered to permit the executive director or the director to issue licenses pursuant to rules adopted by the board pursuant to subsection Parent 3, Parent A of this section. The current rule, as it's worded, is a delegation of authority from the board. However, the authorizing statute does not give the board permission to delegate this authority. This is a technical legal thing, but rather gives it the authority to permit the executive director, etc., to act. Therefore, the regulation needs to be amended to recognize the authorization the legislature has actually given. Next comment. The statutes have changed since the rule was written. This is particularly the result of the sunset that we just finished last year. Now, the director and the executive director are the appropriate figures to receive the authority, not the executive secretary and the auto industry division. Now, also, the authority the legislature permits must be expressed not in guidelines, but in board rules. Therefore, all the above need to be addressed in an amended rule, and the proposed amended rule reads, the board authorizes the director, the executive director, and the agents of the director or executive director to issue, according to the board's rules, any license within the board's authority. So it's not a delegation now. It now mines the store correctly with the proper players as they were revised by definition and statutory change in the 2017 legislation. And it basically allows the same things that are going on anyway. Okay? Are there any comments, concerns, questions about this amended rule language? I know, I just wanted to remind you that I'll talk about that. That's all I'm taking.
Yeah.
Guys, just.
Technically, those are rules.
That's what they use, all right?
Right.
Just didn't want to make sure that it didn't pick that. So,
Well, we're just, Todd was asking a little distinction between the rules that the board implements, such as the license, the $100,000 net worth, the 700 score, those aren't technically rules. Those are just actually, I guess we call them guidelines that are set out, by the board, that the division uses, that the board uses in order to initiate the license. So, because it addresses that part of it as far as the board's rules, but do you want to amend it to say guidelines as well in that circumstance, or? Because that's the one question I said is, those are not actually, it's never been adopted by the board as a rule. So, but it's, to me, it's a guideline, which the board, I think, has the authority to go ahead and issue guidelines. Does that make a difference to you? I mean, is that anything that needs to be addressed now, or because I'm fine with the way it's written, but it is a little.
I totally agree with you that the board has the ability to do guidelines.
Right.
Absolutely.
And there's case law that, under the APA, that recognizes there's some distinctions there.
Right.
There are several types of rules that don't even require rulemaking, technically, under the APA. And the concept is there's a certain boundary that rules set that go right up to the scope of the statute. But even there, you could have a rule that allows for guidelines, and we have several like that. And this is an example you're talking about.
Yeah, and doesn't the statute something say to the effect that the board may issue a license based upon, did they use the word criteria? Did they use the word criteria? Or they use something that allows those guidelines that have been implemented.
Right.
And I just don't remember what that word is, whether it's guideline or criteria.
There is a provision.
Right.
So, Mike, if you look at the proposed change, are you maybe recommending that after to issue according to the board, the end of the second sentence, according to the board's rules, comma, guidelines, comma,
criteria, I mean, if you can go there, just so I think it helps to, not set something up going forward where somebody says, all right, this was denied. Where's the rule? It's not a rule. That's the whole thing. And I mean, everybody has the opportunity to go, but I think it's just a little clearer.
Again, you're giving the board greater flexibility.
Yeah.
And actually the division greater
Flexibility.
to enforce the board's.
I don't disagree.
Yeah.
So adding the word guideline in there?
Yeah.
Yeah. That takes you guys out of stepping in a trap, and the board stepping in a trap. Right. Well, yeah, I think we just do guidelines. I think that is a guideline. It's been adopted by the board. Does that make sense?
It does to me.
And I'm glad Todd context more. I never really thought about it until you brought that up.
Any legal considerations on adding that, Mr. AG?
So the language itself in the statute, this is the reason we went with what we did, is 12.6.104 3D, Roman numeral 2, is to permit the executive director or the director to issue licenses pursuant to rules adopted by the board pursuant to subsection 3A of this section. So that's where we came up with, according to the board's rules and the proposed language. But my understanding is that you're proposing adding and guidelines or something like that, following the board's rules to that language. Would that be?
I think that makes sense. So that way, the division and you know, and maybe there's somebody other than Mike and I are out there that is an attorney that comes in and says, hey, I'm going to challenge this because, you know, my guy, you know, where does it say that this is a rule that you have to have 100,000, you have to have 700? Let's not get into that. I mean, it's been going on for years. Let's clean it up and just use it as a guideline. That way, I think we take the potential pitfall out of there for everybody.
Or we don't get through the OLLS review.
That's the only concern, is that OLLS may say, what are these, there's nothing that's provided in statute for guidelines.
Where do I find those guidelines?
Yes.
Exactly.
But the board through the years has adopted its own investigation guidelines. Has it ever incorporated, I mean, because you signed a long time ago investigation guidelines. Do you remember? You don't remember that? You had, when you were the president back in like, what was it, 04? 01, 02. I actually got a copy of those for a case I had, but I guess if that's a problem, that's a problem.
Well, guidelines, the board has multiple guidelines. I mean, if you think about it, an approved license, an approved application is a guideline.
Well, the defining matrix is just that, it's a matrix. Has that been adopted as a rule, or is that just a guideline?
That's a guideline.
Guideline, yeah.
And we perceive, if we get through this, that we will go back and revisit those guidelines. I think Mr. Perkins wants to take that on, those guidelines, that those level 1, level 2, level 3, level 4, and can we redo those?
Right.
And I would really, if the statute allows us to do that and allows the board to keep guidelines, the statute says rules, but by putting the word guideline in here after rules,
The concern is whether it's beyond the scope of the statute.
And I'm looking right now, I think this is actually far.
Well, how about this? According to the board's rules or authority. And it says that the current, you know, on the CCR, according to the guidelines established by the board, how about you say according to the board's rules or authority? And doesn't its authority involve the actual guideline that's set out as to, you know, $100,000, all that type of stuff?
I mean, obviously, I'm not an attorney, and we get questions from pre-licensed individuals questioning about the rules and what it takes to obtain a license. And now we say, well, the guidelines are this and this, and if this says rules, my question was, well, where do we see that specific stuff that we can show somebody, well, this is what it is? Then that doesn't change with this?
I'm agreeing with you. I would like to be able to put the word guideline in there, because a guideline allows the board allows the board flexibility to change at any time for the right reasons without going into rulemaking.
Right.
I mean, every time that you have a little change that just the board discusses and it just makes sense, then you don't have to go into rulemaking. The board can do. If you don't have, if guidelines isn't allowed here, and because OLS says it's beyond the scope, then does the board have to then put those guidelines now into a rule? Do we find a place that they have to, everything that the board does in a guideline, does that need to go into a rule then? And I would be personally, non-attorney, non-OLS, I'd be really opposed to that because that is going to really be difficult.
Because didn't the issue, because the bond amount actually is within the guideline, not an actual rule amount, or is it a statutory amount? I don't remember.
The bond is in statute.
Is it a statute? But, okay, so that would have been changed, but wasn't there discussion before to take the net worth part of it up at one point?
Mm-hmm.
So how are you gonna go ahead and take the net worth part of it up at some point with,
Yes.
yeah?
I want to call a little halt here for a second, because 12.6.104, paragraph 3D has two parts. Part Roman numeral 1 is to issue through the Department of Revenue and for reasonable cause shown or upon satisfactory proof of the unfitness of the applicant under standards established and set forth in this part 1, to refuse to issue to any applicant any license the board is authorized to issue. That is a qualitative kind of statute, thus allowing the board to set standards to issue or to deny on substantive grounds, on the grounds it has available, through the guidelines it may develop. Whereas this parent 2, the Roman numeral 2 they're talking about, is much more of a restrictive provision to permit the executive director or the director to issue. The word issue is the key. What does it mean to issue a license? That means to physically deliver that license at the conclusion of an approval process. But it doesn't give, that's not a place where the approval process exists in parent 2. It exists in parent 1. We're dealing just with the authority to have the executive director or the director. Remember, the executive director is the EDO, is the individual at the top of revenue, or the director, meaning the individual in Bruce's role. This is not an executive secretary now. This is the line of authority where the director is hired by the executive director and the staff are hired by essentially the director. And so all these functionaries are under the EDO's command role, not under the executive secretary role, therefore not under the board. So this is the board has the authority to permit the EDO as such to issue a license. If you look at the license, who signs that? It's signed by the executive director of the revenue department. Okay? And this may be just the provision that gives the authority to do that. Just to issue.
Not being a lawyer. Thank God.
I was just thinking that myself.
I think you just pointed something out that's critical. If we leave this alone, leave this proposed thing alone for all the reasons that you're concerned about, the board already has statutory authority under D1 to do standards.
That's right.
We don't have to do it.
Those standards go to the, under 6.118, unfitness doesn't get into, it mentions net worth, doesn't get into bond, doesn't get into a lot of the things, or actually, it says it does the creditworthiness, it does net worth, but those are things to consider for fitness of licensing character, but there are other things that are within the guidelines that aren't within the actual regulation. So there's disparity, I think, between the actual regulation and what would be one. And let me give you the example. The issue I'd have is, you have the authority right now to go ahead and issue a license, but somebody called me, got a 690 credit score. That's all right. It's kind of been thought of that if it's close sometimes, but if not, if it's below 700, it goes to the board. Is that discretionary at that point at 690? You can say it, or at 680 or 670, because there's that kind of, where do I tell people it doesn't go before the board based on all the other factors, but it does go before the board because of 670, 680, 690. Whereas if we had something that gives you that discretion based upon what's already been set out and not tied into the regulation, because I think the regulation, the way it's worded, doesn't contemplate all the other factors within the, the $100,000 net worth, the 700 credit score, those things.
Mike,
And I'm not trying to complicate. I'm trying to simplify to not have somebody walk up and say,
No, I think we both understand that. We just want to make sure we come up with something where it's not before the Committee on Legal Services or Legislative Services, I can't remember the specific title, and then the rule is eliminated. That's the only concern. This is something I'd have to look into and look at the APA in a little greater detail, and then just come back and we could either do another stakeholder meeting or it's something I could bring up at the rulemaking hearing itself. But I see exactly where you're coming from and the concerns where either add language that says in guidelines or criteria or something a little bit more broad and authority, something along those lines, and then determining which of those would work in that situation.
way to go, Todd.
So my argument that the board, so under D1, the word is standards. My argument is a standard is a guideline. Okay? So, and I understand you have to look at it from all the legal aspects, but from a non-legal, a standard is a guideline. So is there a need, can we go forward with this proposed change as is and just and look at D1 because the standard, it says standards, is that not a guideline?
That's a good point, yeah. That probably makes some sense. That
So,
would be an easy way to get through.
so do we change the word, so we have and probably Jerry has this when he teaches the class, we have this guideline document. It's a couple pages, I think. It's on our website. It's a DOR form of what the board established 5 or 6 years ago in a guideline. Do we just change that word of guideline to standards? This is the standards that the board is looking at.
Sure. Certainly, the goal is that we don't want to have standards or guidelines in rule. Because then we're getting into, I mean, we all understand net worth, and that's a formula, but you talk about credit scores, and so what bureaus and what formats, and you could never get that into rule. We would be handcuffed.
What if you just write, I don't know if this is a problem, but what if you just change the authority for the standards and write a separate rule?
We could certainly.
Or just reference CRS section 12-6-104 3D1 pursuant, the board authority pursuant to CRS section 12-6-104 3D1.
So looking at the APA, 24.4.104 subsection 2 talks about every agency decision respecting the grant, renewal, denial, revocation, suspension, annulment, limitation, or modification of a license shall be based solely upon the stated criteria, terms, and purposes of the statute or regulations promulgated thereunder, and case law interpreting such statutes and regulations pursuant to which the license is issued or required. Goes on to say, terms and conditions or requirements limiting any license shall be valid only if reasonably necessary to effectuate the purposes, scope, or stated terms of the statute pursuant to which the license is issued or required.
I think that's it there then.
So it talks about criteria, terms, and purpose of the statute or regulations promulgated thereunder. It's helpful in a sense, but it's also, we don't know if it could be interpreted differently by a reviewing entity, so.
Thank you. Then, based on what you guys said, I don't know if I could keep it the way it is. And I mean, I think we all kind of come to the same conclusion that there's criteria, there's standards, and it's set forth in the statute. So it doesn't need to vary from rules because there's already enacted standards.
I mean, that would be my non-legal argument, is that the board already has that authority granted to them in statute to set standards.
Right. Right.
So, say,
But that, we're gonna wheel right back around to this narrow reading. The board authorizes the director, the executive director, and the agents of the director or executive director to issue according to the board's rules any license within the board's authority. It's an issue, a license thing in two, not a evaluate, determine why to issue. I mean,
Well, but I think we are sawing sawdust here a little bit. The way that it's proposed, it is an issue. And so only the board has the authority to issue a license. Only the board. It's the board's license. They are the state licensing authority.
right, so the delegate.
So they have to authorize somebody to do that, because we touched 22,500 licensed transactions. I don't think the board wants to see 22,500 transactions before them. So that's an issue. I think you've got it. It's an issue. Okay. So I think this gets there, that it is authorizing the director to issue those licenses.
so are you proposing adding language?
No,
then?
I'm proposing to
Okay,
leave it
just
exactly
leave it
the
as-
same.
Because you issue the license based upon the standards that's already been set
Right.
forth by the board. And if there's any issue with regard to if they meet the standards, then you send them to the board for their final determination.
And I have a delegation, a
Right.
pretty lengthy delegation of authority from the board to accomplish that. We may have to revisit that delegation and change some words in that delegation. But that delegation gives the division the ability to do that.
That makes sense.
Okay, so we'll leave it as written, knowing that the board, under the APA, is to consider criteria, terms, and the purposes of the organic statute, in addition to the rules.
And is the word criteria and standards the same thing? I mean,
If the APA language were to come before the OLLS anytime soon, they would say, that's wrong to have two words there. Trust. Just a footnote.
so is everybody okay with that?
Yeah.
Go, at least moving forward with that,
Yeah.
not putting guidelines into this.
That makes sense.
Just referring back to the statutory authority of the board.
That makes sense.
Okay. 5.
The end is near. All right, Rule Pair 5, our final consideration today. All right, the introductory comments here are kind of interesting. Okay, the statutory changes as a result of the sunset legislation, in the staff's opinion, remove the need for this rule. The roles of the executive secretary, the director, the executive director, and the board with regard to initiation of investigations are spelled out more carefully than was the case in earlier statutory language. And therefore, this is one that the staff is recommending just be deleted as unnecessary, because the statutes make clear the way in which of these procedures operate. And so that would be it. And so the question would be, now in case you're wondering, where are those statutory procedures? We're talking about section 12-6-104, parent 3, parent F as in Frank, parent Roman number 1, and section 12-6-105, parent 3. Plus the definitions that were changed in the definition section of the enabling statutes.
Here again, I think this rule is just unnecessary. The statutory authority is already there for everybody. The rule doesn't enhance anything.
And I'm not going to make a comment.
Todd, you need your day, son, come on.
Does anybody have any heartburn with moving forward, at least at this point in time, just eliminating this rule? Okay.
Well, thank you all for enduring my presentation.
Okay, so let me go back to the agenda, see where we're at here. Any public comments? So now we need to talk about whether or not this group, stakeholders, want a second meeting, which we've already have it scheduled for Tuesday, July 31st at 9 a.m. It appears to me that, at least at this point in time, we have as close to consensus as I've ever seen on moving these forward. The only thing we're really changing is some of that wording on that first one. The second one we went through that Mr. Dahman with that wanted to add some wording about aggravation and mitigation. We will obviously we will do that. So the purpose of a second meeting would be to rehash all of this and look at just those additions. Or if there's no need to have a second meeting, we obviously put it together. We then do what we need to do internally here with the Secretary of State's office, and all of these issues, any of these, I shouldn't say all these issues, there wasn't very many, any issue can be re-debated at the board hearing. Need for a second meeting. Therefore, I think that we will just move forward with that, and the hearing will take place. As of now, there was debate at the last board meeting, and it was my debate of whether or not we could take this on a public hearing at the normal board meeting of September, the normal September board meeting. I was somewhat opposed to doing that at that point in time because I was concerned that we don't know how lengthy the normal board meeting would take. So I didn't want to do that. I wanted to set that at the second meeting in September. I have since learned from numerous people that the second board meeting is problematic for them to attend, including a board member or two that really needs to be at a public hearing. So based upon our near consensus, if not consensus, I don't think that the public hearing at the board meeting is going to be a 4-hour affair. And therefore, I think that we will just keep it at that normal board meeting. We'll schedule it probably at 1 o'clock. It'll probably be a go-to-lunch meeting for the purposes of Mr. Perkins at that board meeting. We'll schedule it at 1 o'clock so we can take care of it all in one day. So that would be my thoughts moving forward.
It certainly was really helpful to have some new proposed rules written in advance to discuss, so we weren't starting from just ground zero to accelerate. This was great. Good job.
The staff spent a lot of time, but Ms. Rouse and I spent a lot of time debating this stuff, but the real work was done by Leland with the assistance of Brad, and that's where the real work was done, so. Okay, hearing nothing before the stakeholder meeting, we will adjourn Group 1 and time is 11:16. Thank you all for the attendance.